school students to the law via online programs. He's the founder of FantasySCOTUS.net, the internet's premier Supreme Court fantasy league.
Guys got to register.
Unprecedented, the constitutional challenge to Obamacare. He's a graduate of George Mason School of Law. He is clerk for the Sixth Circuit and the Western District of Pennsylvania. Also, Dean Mulroy, of course, he's our Associate Dean of Academic Affairs. Of course, he's a professor specializing in constitutional law, election law, and civil rights. He's a graduate of William & Mary College of Law. He's clerk for the Northern District of Florida. He was an attorney for the Civil Rights Division of the Department of Justice from 1991 to 2000, federal prosecutor in the U.S. Attorney's Office from 1999 to 2000. He joined Memphis Law Family in 2000. He served on the county commission here in Memphis from 2006 to 2014. And he was recently one of 3 names considered by the White House to fill the vacancy at the U.S. District Court of Western Tennessee. Welcome Professor Josh Blackman and Dean Mulroy.
Thank you. Can I sit down? Can you guys hear me? Wonderful. So thank you very much. It's a pleasure to be back in Memphis. I was here about 3 years ago and I've been very warmly welcomed. We are at a turning point of sorts. The Supreme Court, as I'm sure you're all well aware, is down to 8. So for the first time in any time I can think of, the election will be a direct referendum on the Supreme Court itself. Whether it's Hillary Clinton or Donald Trump, the next president will appoint the 9th justice. And to make a point clear, the Federal Society takes no position on either candidate. It's not a political activity. My discussion will be far more narrow. How are these 2 individuals approaching jurisprudence and constitutional law? And how will the sorts of justices they pick perhaps the direction of the Supreme Court? So to give you a very current illustration that happened yesterday of how divided the court is, the issue came up of a voter ID law from North Carolina. The Fourth Circuit Court of Appeals held that this law violates the Voting Rights Act. That was a form of discrimination. It was appealed to the Supreme Court saying, hey, SCOTUS, put this on hold so we can have our election. The vote tied 4-4. Had Justice Scalia been there, I think Dean Mulroy will agree, it's a pretty safe bet that the North Carolina voter law would have been allowed to go into effect. The 4-4 tie, it was simply affirming the lower court, which said it can't. So we're at a very crucial turning point of where the law goes. So first, let's talk about the candidates. Secretary of State Clinton, who's the Democratic nominee, clear a few of her so-called litmus tests, and she's used that word. Now, what's a litmus test? You may not have heard that phrase. Do you all have swimming pools, right? And you have to measure the pH of the water in the swimming pool. You put a litmus strip in, right? You know what I'm talking about. A litmus test is a way of saying, okay, going to vote on a specific issue. And for decades, as long as I can remember, it was said we do not ask for judges on litmus tests on abortion. That was always the case. You can't ask a justice to be, so what do you think about Roe v. Wade, right? What do you think about a right to abortion? You could not ask that. Why? For a reason. The rules of ethics, which you all study, says if a judge says his opinion on a certain topic, if that topic comes to the court, he has to recuse, right? You can't sit on a trial where you've already expressed your opinion. So this is why judges historically, when you ask them, they say, well, you know, I can't decide, I can't discuss, you know the drill. That discourse has changed with this election season. Both Bernie Sanders and Secretary Clinton have said, we will want to appoint judges who will overturn Citizens United. She said, quote, I'll appoint Supreme Court justices who recognize that Citizens United is bad for America. So I doubt that at any point someone in her White House would be stupid enough to ask, so what do you think about Citizens United, right? They don't ask that question. Saying this is more or less suggesting what her nominees to be will look for. As well as usual, the Democratic nominee says she'll appoint someone to uphold the right to abortion, recognized in Roe v. Wade, and then modified by Planned Parenthood versus Casey, and modified again this year by the Holdren's Health decision. So that is pretty much standard. The Republican side, the sorts of, do not disturb cases involve the Second Amendment. Heller, District of Columbia v. Heller. This was a 2008 decision holding that the right to bear arms is an individual right. And Donald Trump has been very think about this. He says over and over again, if you vote for someone else, the Second Amendment's gone. He says this in many different fashions, that a fifth vote on the Supreme Court will overturn Heller and get rid of your Second Amendment rights. I'll get to the Second Amendment in a few minutes. That's not exactly probably what's going to happen, but the Second Amendment has been a big function. Trump has made the case repeatedly that even if you hate me, the reason to vote for me is the Supreme Court. If you like nothing else about me, vote for me to avoid giving the Democrats a Supreme Court seat. And he's made that point over and over again. And I can say from personal experiences, a lot of conservatives will hold their nose for the issue of the Supreme Court as well. This, my friends, is a testament to how important the Supreme Court has come. That this may be, for a lot of people, the most important confronting us. Okay? So I don't want to get too far into whether it will be Merrick Garland or not. Merrick Garland, of course, was Barack Obama's nominee to the Supreme Court. He's a well-respected D.C. Circuit judge. But one point that I want to raise, during the entire Democratic National Convention, do you know how many times Merrick Garland's name was mentioned? 0. His name wasn't mentioned at all. Why? He doesn't rile up the base. He's another white male in the Supreme Court. He was not received with enthusiasm. So I think the fate of Judge Garland depends in large measure on what happens in the election. If Hillary Clinton wins the presidency and the Republicans have a sizable lead in the Senate, she'll probably keep him because he has a greater chance of passing through. However, if the Democrats win the White House and have a sizable lead in the Senate, he may pull the name out and put someone more progressive, more liberal on the court. So there's this weird game of chicken and will ever actually be confirmed. I think all of it depends on the election returns starting in November. So let's move on, okay? And let's say, for example, that Hillary Clinton gets to appoint one justice. Let's stick with one. If she gets 2 or 3 later, that's a different ballgame. But let's start with one, which we know will happen. What does that mean for the future of constitutional law? So the Roberts Court historically has not been big on overturning precedent. Their usual approach is to simply distinguish it, read it narrowly, saying, well, this rule doesn't apply here. And I think that principle would actually guide the court as the senior most justice in the majority. So, for example, rather than overturning Citizens United, they can read it very narrowly. What did Citizens United say? Citizens United has been misunderstood very poorly. This does not say corporations give as much money as they want to politicians. Not at all. It involved independent expenditures from corporations to various political activity committees, these PACs. The court can scale that back a little bit by maybe saying, well, if we find evidence of corruption a little bit more broadly, this rule doesn't stand. So you don't need to overturn Citizens United. And that's probably very near and dear to a lot of people in this room, which is Heller. I think it's unlikely that a 5th vote will overturn Heller. Okay, why? Heller, only 2 cities in the entire country banned the possession of handguns. You had Chicago and you had DC. Even if Heller is overturned, it become illegal, right? In Memphis, you'll be able to keep your gun. The Memphis legislature and the Texas is where I'm from. The Tennessee legislature can add additional protections beyond the federal constitution. Most states have a right to bear arms provision. So even if the court overturns Heller, gun laws will stay roughly the same. All the Supreme Court has to do is say, our decision in Heller is final. The Second Amendment applies nowhere else. It doesn't apply to concealed carry. It doesn't apply to having an AR-15. It doesn't apply to having gun shows. Nowhere else. It simply applies to having a pistol in your home for self-defense, which can be regulated extensively. If the court says that, Heller's still in the books, but it's a dead letter, right? It has no more teeth. And because the Supreme Court, when it had Scalia, didn't take a single case after Heller McDonald, of how much potency Heller has. Another area where I think the court could go solidly to the left involves the death penalty and stuff short of the death penalty. So in recent years, Justice Kennedy has hinted that he thinks solitary confinement violates the Eighth Amendment. That is, leaving someone in a cell, by themselves for 23 hours a day with no human contact. I think that's on the chopping block pretty quickly. But more broadly, will the court once again rule that the death penalty is unconstitutional? They tried this in the 70s. It didn't work out so well, so they had to backtrack that. But now what they can say is, well, it's not that the death penalty is unconstitutional, but the manner in which we implement it is so awful, so arbitrary, so this, so that we can no longer have it. If you can figure out a way to do the death penalty correctly, go for it. But the bar will be so high that I don't think any state will be able to satisfy it. Another area where I think the court will probably to the left involves voting rights, and we're already seeing this now. In the wake of the Shelby County decision, a lot of states were removed from what's called pre-clearance. What this means is that if a state wanted to make some change to the voting rules, they need to ask permission from either the Department of Justice or from the federal court in Washington, D.C. The Supreme Court said, wait a minute, the maps which decide which places are under this regime and which are not are out of date. They were created in the 1960s, right? You can't judge people today created 40 or 50 years ago. That's gone. So as a consequence of the maps being invalidated, what we're left with is that the Justice Department brings private suits against my home state of Texas, North Carolina, and a host of other states saying you guys are intentionally discriminating on the basis of race. The Supreme Court historically has not been so keen on these sorts of intentional discrimination cases, but as we saw literally yesterday, 4-4, that 4 justices are willing to say that North Carolina's voter ID law is racial discrimination. You add a 5th to that, that's now the rule. That's not the law of the land. So I think that voting rights is going to be a serious other area. This getting scaled back. In my remaining minute, I want to tease up the how do I put it? The liberal dream, right? Rights. What do I mean by positive rights? So there was a case from I guess it was the 1970s involving education, right? If you have a substandard school district in San Antonio, right? If you have a substandard school district in San Antonio, Texas, right, where these kids are not getting the education they need, can a court step in, supervise, saying, look, the due process clause, the 14th Amendment, where liberty's in there, one of those liberty interests is the right to education. And because the state's denying this right to education, federal courts can supervise it. Now that's a radical holding under current law, because we view our Constitution as a charter of negative liberties. The Constitution says Congress can't do this, Congress can't do that, they can't regulate speech, they can't search your house, they can't do this, they gotta give you a lawyer. We don't have a tradition of a positive liberty, that you have the right to something. In fact, I think Obergefell, the same-sex marriage decision, was the first case which said explicitly you have the right to a piece of paper, you have the right to a government license, right? But it wasn't really based on that basis. So the liberal dream is saying you have the right to education, you have the right to minimum housing. Go down the list. Now, why is this important? Don't we already have state statutes that give you education, whatever else? Sure. But if they're inadequate, your remedy is the political process. You have to go and vote someone else into office. Here is the power to say, no, 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 you can't. And if you want an example of this, look in New Jersey. New Jersey, the state Supreme Court has construed the New Jersey Constitution in such a way that it can supervise education. And this happened maybe 2 or 3 years ago, where the state legislature passed a budget funding schools. And the Supreme Court of New Jersey said, no, that's not going to cut it. Try it again. Courts explicit oversight of budgets. That will be a radical change. I think that is the long-term goal of where jurisprudence is moving. I can address that more during the Q&A. I will stop top here, let my gracious colleague, the dean, give us some insights from his own perspective. And I didn't realize you were on the wait list for the court, so maybe you can give us some insights there too.
Thank you. Let's hear it for Professor Blackman.
Thank you.
I want to thank Professor Blackman for coming all the way from Texas and appreciate his insights. I want to thank the Federalist Society for putting this event on. I've said it before and I'll say it again, the Federalist Society of stimulating the intellectual life of our law school. We owe them a great debt. I have to make some choices here about what I'm going to say because, you know, on the one hand, I was asked to talk about Hillary Clinton and Supreme Court picks, but you know, some of the comments that Professor Blackman made were sort of interesting, and I'd like to respond to them. Let's see how I do. I agree with an awful lot about what Professor Blackman said. This is a leverage election. The future of the court for decades is going to be decided by this election. We have, in addition to Justice Scalia, we have 3 justices who are either already 80 or soon to be 80, will probably be retiring between the next 4 to 8 years. So big change, wave election occurring here with the Supreme Court. To kind of compare and contrast President Hillary Clinton's Supreme Court picks versus President Donald Trump picks is sort of an interesting path because there's such a contrast in the federal judiciary and their temperament. And I'm going to get to that in a minute. But just, you know, by way of contrast, you know, Secretary Clinton is a lawyer, a former law professor who's had decades of experience with how the 3 branches work. That is not true of Donald Trump. Donald Trump is a person who has publicly professed support for the non-existent Article 12 of the Constitution and refers to judges as people who sign bills. It's a little bit difficult to know what's going to happen with Donald Trump. I think Professor Blackman's reference to Merrick Garland is on point. I think I agree with his analysis that it could very well be Hillary Clinton appoints Merrick Garland herself. This would be sort of an easy path to confirmation. He's well regarded on both sides of the aisle. Senator Orrin Hatch, Republican from Utah, has publicly praised him. He actually has more federal judicial experience than any nominee in history. 350 opinions at the DC circuit level, not one of them ever being overturned by the court. Which is why, of course, it only makes sense that the Republicans in the Senate would refuse to give him a hearing or give him any kind of a vote. But the problem that Professor Blackman was talking about with respect to the 4-4 ties is a significant one. It's a non-trivial one. Not only do we not know what the law is, but in some cases, like the case that we talked about a moment ago, the law is different in some circuits versus another indefinitely because of this judicial obstructionism, which will has not only obstructed the last half of this term, but if it's true that we won't get any kind of a vote until January, then that means it'll probably have the same kind of effect for the entirety of the next term too, the 2016-2017 term. With respect to what kind of Supreme Court nominees we might see from either candidate, there have been some names that have been discussed supposedly by insiders in the Clinton camp. The same names keep coming up over and over again. They overlap substantially with the names that have been discussed as the short list administration. They kind of have a common theme. The common theme is people with significant appellate federal judicial experience whose confirmation votes indicated that they diverse at the time would probably have a smooth path towards confirmation and who would promote diversity on the Supreme Court. So just to take a couple of high-profile examples, Sri Srinivasan was confirmed 97-0. He is a good friend of Ted Cruz, reportedly served in the Bush Justice Department, has been on the short list for a while. He would be the first Indian American, the first Hindu to make it to the Supreme Court, and the first immigrant in over 75 years. There's another judge on the Ninth Circuit, Jacqueline Nguyen, who similarly had a 93-1 confirmation vote, is well regarded on both sides of the aisle, would be the first Vietnamese American to be appointed to the Supreme Court. The list goes on, but you get the general tenor of it. That our guest here is correct that the best insight would be, what are the policy priorities? What are the ideological imperatives and emphases that animate the candidates? Both have said them. both, if you want to call it a litmus test, both have indicated that there are litmus tests. Hillary Clinton has said that she's interested in justices who would see the folly in Citizens United. I don't think that's all that indefensible position to take. Citizens United did say that with respect to making independent expenditures, corporations have the same First Amendment rights as flesh and blood human beings. There hadn't really been precedent for. It did result in a political system in which basically unlimited rivers of cash are flowing into the political process, unaccountable, in many ways anonymously, without proper disclosure, as a result of Citizens United. But perhaps more importantly, the decision itself criticized as a judicial activist decision. Why do I say that? Because the court reached a decision that hadn't really been properly raised below. In fact, it had been expressly waived below. Constitutional decision that could have been resolved on statute. A facial constitutional challenge when a more narrow as-applied challenge would have sufficed. And it overruled decades of precedent, striking down, and in so doing, substituting the Supreme Court Justice's own judgment about the effect of cash on legislators for the judgment of the legislators themselves. What are the other policy priorities of Hillary Clinton? I think Professor Blackman has correctly identified them. Certainly are important considerations. Voting rights. I agree that the right to vote is going to be a big area in the years to come. You know, one of the things I would say is Professor Blackman mentioned the Shelby County Holder case, the case that struck down the Rights Act that would require some jurisdictions to get pre-clearance of voting changes in advance. What I think will likely happen is that Congress will try to write new standards, have to have pre-clearance and which don't, safe in the knowledge that in a Clinton presidency with the Clinton Supreme Court, those standards would be upheld. Okay, so what about Donald Trump? Well, Donald Trump has his own litmus test, if you want to call him that. He's publicly said that he wants to support candidates who would overturn Roe v. Wade and take away abortion rights, who would overturn the Obergefell case and take away the right to same-sex marriage. Respectfully disagree a little bit with the characterization of Obergefell. First ever instance of the surprise into the Constitution. I think this was another in a long line of cases that use the Equal Protection Clause to say that if the state is going to provide some right in an equal, non-discriminatory manner. So the state doesn't have to provide public education, but if it's going to do so, it can't racially segregate. Brown v. Board. In the business of providing marriage licenses, that could be a matter of contract. But if it's going to do it, it can't racially discriminate, Loving versus Virginia. And if it's going to do it, it can't discriminate against gays, Obergefell. Radical, first in the history of the nation's rights radical revolution. I think it's a straightforward application of non-discrimination principles. He has said to Donald Trump that this is a quote, he would probably appoint people that would look very seriously at Hillary Clinton's email disaster. Well, that quote makes me think that maybe Donald Trump doesn't really understand what justices do, but it also makes me think that maybe he is more than willing to use his appointment power to settle political scores. And this is what I was getting at before about the temperament of the candidate and why it's so difficult to predict what Donald Trump will do. I think there's real reason to have concern for the rule of law. Who has openly favored torture and the targeted assassination of family members of suspected terrorists, an open violation of both domestic and international law. He's openly said that we need to loosen the defamation cases so that public officials will have an easier time of suing media outlets. This is a candidate who's publicly a sitting federal judge a case that he was personally involved in, the Trump University fraud case, because the judge was Mexican. Never mind the fact that he wasn't Mexican. He was born in Indiana to Mexican immigrant parents. He went on to seem to threaten him, saying, "We will come back in November about this judge if I am president and come back and do a civil case." Again, the quote makes me think he doesn't quite understand how federal courts work. But it does make me think that he's more than willing to use his power as a vendetta. He has publicly threatened to sic federal regulators on his critics. Of the Washington Post, believe me, president, do they have problems? They're going to have such problems. Now, am I the only person that is concerned about this? No. There are conservative legal thinkers who are concerned about this.
As am I.
I know you are. Because to be congratulated, he's going to be co-authoring a book with the very, very well-respected conservative legal scholar Randy Barnett. Randy Barnett is the one making these arguments, not me. You'd like a president with some idea about constitutional limits on president. I know of such limits. Richard Epstein, another conservative legal scholar that I'm sure Professor Blackman knows, has openly speculated that Donald Trump would not necessarily feel obligated to obey court orders. Told the Andrew Jackson, let them enforce it way of thinking about it. And my favorite quote comes...
Can you make fun of Andrew Jackson, Tennessee? Allowed to do that, or is that sacred here?
No, it's okay. This is free speech time here. My favorite members here will know Paul invited him to come speak, and we did a debate in the same room. And Ilya Shapiro said, who knows what Donald Trump with a pen and a phone? I don't think I could say it any better. So what would he do with the Supreme Court? Well, his campaign, I don't know if he ever read it, but his campaign has issued a list of 11 names of potential Supreme Court nominees. Many of you in this room will be pleased to hear that all of them are Federalist Society members. Many of you will be unsurprised to hear that all of them are white. And I want to just mention two names, all right, because I'm going to come back to them in a second. Diane Sykes in the Seventh Circuit and Don Willett, Supreme Court Justice from Texas. Remember those two names. The reason I'm not going to spend much time on the list of names that the campaign sent out is that I think there's serious reason to doubt whether any of those names actually will be appointed, because I don't think we have any idea what Donald Trump will do. I'm not even sure that Donald Trump what he would do if he becomes president. He originally said that he thought his sister, who's a federal judge, would make a good judge, but then later on claimed to be kidding about that. Positions we know are all over the map. His signature issue of immigration, he started out by talking about mass deportations of millions of people and a deportation force. Most recently, he said he's going to soften that position and create a path not to citizenship, but to some sort of long-term status. And now in his most recent speech, he's disabused all of that and said, no, go back to what I said originally. And Ilya Shapiro, this is a great list of names. Who knows how much you can trust the list? Remember I told you there were two names I wanted you to remember? I'm going to close with these. One of them, that he can't imagine, quote unquote, Darth Trump trying to select Supreme Court nominees, tweeting out a haiku. And the haiku read, who would the Donald name to SCOTUS? The mind reels.
Can't finish this tweet.
Can't finish the tweet. Yes, can't finish tweets. Can't finish tweet. Yes, we need 5 syllables, right? Because it's a haiku, right? And who was it that tweeted that?
My good friend Donnie Willett.
Right, who's on the list. Who's on the list.
But that wasn't his best quote. His best quote was at some one point, Trump will rip off his mask, Mission Impossible style, with Ruth Bader Ginsburg. That was the better tweet. You picked the less good one.
Yeah, and this is the person that is supposedly on the list being actively considered for the Supreme Court. Does anybody believe that he's actually going to be considered for the Supreme Court? I will end with one other person from the list, Seventh Circuit, who said she'd welcome a Trump Supreme Court nomination and believe him. And neither can I. So I pretty much know what I would get from a Clinton presidency in Supreme Court picks.
Was that Diane Sykes or her husband Charlie Sykes? I don't think Diane said that.
Well, I had it quoted as Diane Sykes saying it.
Yeah, her husband's a talk radio host in Milwaukee, so I'm going to check that. But
yeah, this was the Washington Post. So
okay.
It's probably part of the Watergate conspiracy. So we don't know, whether it's true. But I don't believe him either. And so I think we know what Hillary Clinton would do. Trump, I don't know what we do, but I think we have reason to fear about respect to the rule of law. I'll let them next.
Okay. So it was a pleasure.
I'm going to make a few
Yeah, go for it.
Question and answer. This year, we kind of, not really guidelines, but
It was
just
her
some
husband.
words of caution.
It wasn't
Just be respectful.
Yeah,
With regards to your questions.
it's narrow.
Don't give
Her husband's name is
5-minute
Charlie.
questions, and respect everybody else too, because I know a lot of people want to ask questions. So if you've already asked a question, you see somebody else wants to ask, maybe refrain from asking your question until you see another hand or something like that. Just asking everybody to be courteous of their fellow students when it comes to questions. Secondly, again, I want to thank
Milwaukee
both,
Journal Sentinel.
I'm a professor emeritus of public policy scholarship on primary and secondary sources related to the American founding spans 5 decades. And so he will be coming to help us celebrate Constitution Day here at Memphis Law. Our one request, requirement actually, is that you email Melanie Bush at Public Knows his email address is up on the down there. Please RSVP. As you can see, there's only so much space in here, and we need to know how much food to buy. We have invited over a dozen guests from the judicial branch here in Memphis Federal and state police. So we have good participation there, and we also have the Memphis Lawyers Chapter members here at the school. So it's a great opportunity to keep people in our field. Again, RSVP.
More information going out about that too. We just want everybody to get on the calendar. This is going to be an awesome event. And then, again, before we start question and answer, let's hear it one more time for our speakers.
Actually, Dean, you want to?
Well, you want to do it, Hunter? You're the.
You can pick questions. It's always better when the students pick.
Obviously, we have the election, which has been described as an apocalyptic dumpster fire. And
I'm praying for the sweet meteor of death personally.
that would be fantastic as well. And you mentioned, Professor Blackman, talking about how, whether we have a liberal court, whether we have a conservative court, I mean, you definitely espouse the liberal court would definitely be more activist. But on both sides, we seem to have this issue of the court having to be much more active in resolving questions of law than they have been in the past. And it seems to me that we are kind of ignoring the elephant in the room, that is the legislative intransigence that we've been having to deal with, regardless of whichever party. Both parties seem to be becoming the party of no. It's not a matter of active legislation, it's a matter of obstructionist legislation. And is there anything that's either A, through the courts, or B, any other routes, and Professor Moore or Dean Moore, you can address this as well, that can seem to break that? It seems to me if the legislature begins actually legislating and doing their jobs, resorting to the courts to further agendas or expand the law in a way because it's the only method of recourse, because it's the only branch of government that actually seems to be able to do anything.
So I have a piece coming in the Harvard Law Review this November called Gridlock. That's the title, one word, Gridlock. And it discusses the relationship between executive power and the courts when Congress, to use the word obstruction, or maybe I would say doesn't pass laws. So I'll give you guys an interesting statistic you may not know. Every year, people are polled the question of, would you be okay with your son or daughter marrying X? And one of the questions they always poll on is, would you be okay with your son or daughter marrying some of the opposite race? And in the 1960s, it was really high, right? I would not want that. But that number has been going down. And we're at the point now where it's a pretty small percentage of the population says, I would not want my son or daughter marrying some of the opposite race. Progress, right? Good.
would you be okay with your son or daughter marrying someone of the opposite political party? That is, if your parents are Republicans, would you want your kid marrying a Democrat? Or if the parents are Democrats, would you want your kid marrying a Republican? Those numbers are going up. And this is what Cass Sunstein is called partyism, not racism or sexism. We have another ism, right? Racism, sexism, partyism. The fact of the matter is the American populace is divided more so than at any point, well, I'm in Tennessee, but in a long time. People simply don't agree. So it's not surprising then that the people they sent to Congress also disagree. The intransigence you speak of in Congress, which is indeed present, I think is a reflection of the American populace. And until the American populace agree, likely that Congress will agree. And the article I wrote for the Harvard Law Review says the president has seized upon this intransigence as a license to expand his executive power. And my response to that is no. We have gridlock built into our Constitution. Unless we have both houses of Congress agree, there's no law. There's no law. We don't have a parliamentary system where if Congress doesn't agree, you have to hold an election, get a new prime minister, and again, legislate freely. We don't have that. It has these veto gates, they're called, to check when we don't have enough consensus. Now, do we get rid of the filibuster? Maybe that's what you're asking. There was a thing in the New York Times an hour ago. Democrats, Harry Reid says, maybe we'll get rid of the filibuster altogether. That would be one way to make it easier to pass laws, but it can come back to bite you in the butt when the other party's in power. Ian?
Well, so I agree partially with what I've just heard. It's certainly the case in terms of American attitudes that polarization has increased over the decades, but I don't really think that by itself is necessarily the problem with gridlock. I think there are structural impediments, and Professor Blackman has already mentioned one of them, which is the filibuster. Time was early in our history, the filibuster was invoked very, very rarely, and only in the most extreme circumstances, and you had to actually be physically present. Like Mr. Smith goes to Washington. You had to sit there and read from the phone book until 2 in the morning, right? Then, some number of decades ago, they changed the rules and said that you could just have anonymous holds on nominations, and you could do a filibuster just by signing a piece of paper. You wouldn't have to physically be there. And changed so that filibusters would occur on every time you had a policy disagreement. If you could filibuster, you would, and that led to the gridlock. So getting rid of the filibuster would be a good idea, and I think it would really, really help a lot. Certainly with confirmations, and I think with a lot of with treaties, and certainly with a lot of legislation itself.
You can't get rid of treaties. That's in the Constitution.
Okay, all right, yeah, that's true. But the other institutional concern that I would mention is the gerrymandering in the House, which again has increased a lot over the last, let's say, century. It used to be the case gerrymandering would occur, well, let's say, it used to occur a lot until the courts started policing it, and then it started to reduce again. But with the increasing use of computer technology to really, really fine-tune the gerrymandering, because of some Supreme Court decisions that I disagree with, the courts have basically backed out of policing that area. We now have rampant gerrymandering in the House.
I mean political gerrymandering, not racial or political? Which
I'm talking about partisan gerrymandering.
Political gerrymandering. Okay, that's different than racial gerrymandering, which is under the Voting Rights Act still.
Yes, I know. I'm talking about partisan gerrymandering. The partisan gerrymandering is really what's driving the gridlock in the House. The filibuster is driving the gridlock in the Senate. So if we had structural reforms, then I think we would get rid of the gridlock, irrespective of the ups and downs of American attitudes about polarization, which over the course of our history have gone up and down over time. And the final thing I would say, just real quick, Zach, I don't know whether you meant to phrase it this way, but just for the record, I'm not sure I would agree that a Democratic appointed Supreme Court would be more activist. It would certainly be more progressive, but I don't think it would be more activist. I think that conservative Republican appointed justices are also very activist.
Would you define the word activist?
Well, I tried to earlier with Citizens United. I think one person's activism is going to be another person's reasoned decision, right? It is going to be based in part on whether you agree with the outcome of the decision. But if you were to try to come up with some neutral principles that would help you define activism, kind of the things that I talked about with respect to Citizens United. To what extent are you striking down laws, overruling decades of precedent, reaching issues that had not been properly raised below, reaching issues that have been committed to the sound discretion of the political branches through the text of the Constitution, reaching constitutional issues rather than statutory issues, and reaching facial challenges as opposed to as applied challenges. Every one of the criteria that I just mentioned applies either to Citizens United or to Bush v. Gore.
What a Roe v. Wade.
Well, maybe. I wouldn't dispute that Roe v. Wade is an activist decision. What I'm trying to suggest is that in our recent history, there are just as many examples of right-wing activist decisions as left-wing activist decisions. In fact, what the right has had over the Supreme Court in the last few decades, the real activist decisions have been from the right and not from the left.
Yeah, I think the word activist has no meaning. Activist is a decision you don't like. I appreciate the factors you mentioned, but I can go for every Roe v. Wade, there's a Bush v. Gore. For every Citizens United, there's an Obergefell. I can go back and forth either way. But I think we're more or less on agreement of what could happen in the event that the core and left are right.
Yeah, my question was going to be, one of the issues y'all both talked about was if Senator Clinton or Secretary of State Clinton is elected, that one of the platforms will be to protect a woman's right to choose. Do you think that will extend to overturning the precedent of the Partial Birth Abortion Act?
Further.
Yes.
Oh, do you want to take that one?
So the question is, if it's a Democratic-controlled Supreme Court ruled the decision that said that it was okay to have a partial birth abortion ban.
Right. Do you think that right to choose extends that far?
Do I personally think the right to?
Do you think
Even further, you're asking.
Well, I mean,
Will they overturn Gonzalez v. Carhart? Is what you're asking?
yeah. I mean, and it's possible that they might, but I don't know how likely it is because ban partial birth abortion applies to a specific type of surgical procedure that doesn't come up all that often.
It's really narrow.
It's extremely rare that it occurs. So the political pressure to overturn is going to be as great because it doesn't come up as often as a practical matter. So I guess my answer is maybe with the liberal court, but it wouldn't be high on the priority list.
The case we talk about is Harris v. McRae. This is whether there's a positive right to funding for abortion from the government. This is what was alluded to before. RBG has said for years that was one of the worst decisions ever. I think that precedent could be in jeopardy. Why isn't the government paying for it? I think the argument's specious, but that's the case.
Well, yeah, I think that's true. I would agree with that.
Yeah, progress.
So, given Merrick Garland's track record, given that there's no guarantee that Secretary of State Clinton would keep him and potentially go even more to the left than appointee, and given the fact that there's no guarantee the Republicans will win the election, why do you think that they won't have a hearing for Merrick Garland?
When? The question is when. When? You're asking before the election, after the election, before January 20th? At what point are you talking about? Well, look, so I'll reply to something you said. The Senate not holding a hearing is not obstruction. The Constitution says the Senate has the power, if it chooses, to give advice and consent. Their advice can be come back later. This has happened before. And even before the Constitution, it happened. In the Massachusetts Supreme Legislature, this is where we get the phrase advice and consent. They would simply tell the governor, no, we don't want to have a hearing now, pick someone else. There's no obligation of the Senate to hold a hearing. The check is political. And in case of this year, it's really political. Go vote against Chuck Grassley, primary him, take him out of office, right? He's the one making the decision. But the Republicans made the choice, and again, it's a political decision. They were banking on a Republican winning the White House, keeping the seat open for about 8 or 9 months, or whatever it happened to be, and then confirming someone after New Year. Now, that decision was made before it was clear that Donald Trump was the nominee. Back in February when Nino died, it wasn't clear who the guy was going to be. Now it's Trump, who, as Fred Dean alludes to, I'm not a fan of. So they're in this weird spot. Now, a couple of days ago, Grassley said, well, maybe we'll have a lame duck confirmation hearings, that if Clinton wins, maybe they'll rush Garland through in November and December. I can see that happening. I don't think it's likely. I think they'll let the Democrats own this guy. It won't be their own. I don't see a justice be confirmed until the earliest, probably March or April 2017. I think that's probably the earliest we'll see a justice confirmed.
I think that the term obstruction is appropriate for this reason. This really is unprecedented. History, when the president nominates a Supreme Court justice, there's a hearing and a vote. It usually happens within a couple of months. The fact that this is occurring in an election year, which is the excuse that the Republicans in the Senate has given, doesn't really wash from a historical perspective. There have been 32 times in our nation's history. 1 year of a presidential election, a president has nominated a Supreme Court justice. And every time there's been a vote, about half the time they were confirmed, half the time they weren't, but nonetheless there was an up or down vote. And it occurred most recently with respect to Justice Anthony Kennedy.
Oh, but that's not fair with Robert Bork. That's not a fair comparison.
Justice
Well,
Anthony Kennedy is exactly what I just talked about. He was nominated
in
and
January of
confirmed
'88.
within a year of a
Well,
presidential election.
he was nominated in January of '88 after Robert Bork was killed and Doug Ginsburg was killed. That's not exactly an analogous comparison. The more analogous comparison.
What about the 15 times in our nation's history in which
true.
a president has nominated somebody in the same calendar year as a presidential election and the Senate gave him a vote? Are any of those analogous, or are they all distinct?
There's examples, right, of this happening before.
This is unprecedented, and it's completely unprincipled. And the fact that Chuck Grassley and other Republican senators are openly discussing a lame duck confirmation only if their candidate loses reveals the naked, unprincipled nature of
But what's
the
wrong with
position.
politics? The Constitution says advice and consent. Legal decision.
The intellectually, I'm not saying that you can sue.
Senators have
article-
intellectual honesty.
I'm not saying.
They don't.
I'm saying that intellectual honesty is not too much to ask from our elected
Oh,
officials.
I think it is.
And just to finish the point, the intellectually honest thing to do is if you don't like that nominee, give a vote and vote him down and publicly say, I'm voting him down because I disagree with his ideology. Then you are accountable to the people. This destroys accountability. It is hiding behind a fiction, and it is unprincipled. And you can't deny it's unprecedented in our nation's history.
Yeah, I don't give politicians a damn worth of principle. They're politicians. If this was so bad for Iowans, they vote out of office. If there's no point. They're making an election issue in Iowa out of office. Okay, we have time for more questions? Another question. Oh, come on, you guys. What time do they have class after this? Yeah, go for it.
For Professor Blackman, I guess and I didn't hear the very beginning of what you said. I walked in late, so I may have missed something.
I answered your question the first 30 seconds, but
You know, when I came in, you were talking about kind of criticizing the litmus test that Clinton and Sanders have been, I guess, putting out there, right, for their candidates. But you said, what's wrong with playing politics?
the confirmation process.
But so the Senate is playing politics in a way that's okay, but the Democratic candidates were playing politics in a way that's not okay.
So you're trying to do a gotcha, so I'll explain this. The Constitution vests the Senate with an absolute power. Absolute. They can say, we don't want to hold a hearing, we want to vote no, we don't care.
Does it require a filibuster?
The Constitution is silent by filibuster. It
So
says
then-
nothing.
So then,
But the Senate, by its own rules, which the Constitution
Right,
allows
so-
to set, can
so
create
it
a
wouldn't be
filibuster.
unconstitutional to do what I said before about the filibuster, right? It wouldn't be unconstitutional. It would just be against Senate rules. Which
But
could
the
be
Senate,
changed-
the
which
Senate
could be
can change.
changed at any time by
So-
a majority
and
vote.
indeed they did. Harry Reid eliminated the filibuster. But to
You know
answer your question, the problem with the litmus test is not one of executive power. Because, and I actually did answer this question before you got here, when a judge to be says, I'm going to rule in a certain case, if that case comes up, they have to recuse. That's not a very good way to get a justice in the court. That's why during confirmation hearings, judges do this gymnastic routine to avoid answering any meaningful question. That's not the real reason why, but that's the reason they say we don't want to have to rule in a case. So I don't think there's anything wrong with the choose a liberal. If Hillary Clinton wants to choose Nina Pillard or Paul Watford or whoever else the dean mentioned, I mean, that's her prerogative. And if the Senate thinks that person is not a good choice, they can vote that person down. But once you give that person a lifetime commission, so you better be sure the person you give this commission to meets whatever conditions you set.
And I'm going to give our esteemed guest the last word and not say anything.
That was my last word. Thank you all so much.